Good day. I'm Barrister Mrs. Ijeoma Maximilianozie. I'm the principal partner at ICNT Legal Practitioners, which is a leading law firm based in Lagos, Nigeria. And this is the ICNT Law Lecture Series. Today we'll be discussing a particular secret which I have observed that would help all marketers, particularly in Nigeria and even abroad as well. There's been an influx or an increase in the demand for marketers recently, and that's owing to the need for companies and businesses to maximize profits and want to break even. They recruit marketers and set them out to go gather in customers, on the promise to give them a certain percentage as commission, or some even go as far as placing them on salary. This video is particularly of importance to the marketers. Before you go on to celebrate your new job, your new 80% or 100% or 10% commission, or your fat salary which some companies give to the marketers, it is necessary for you to know that you need to protect your interest. Now, these companies usually give the marketers an agreement, a sort of an agreement, or some people use like a pre-printed form which they give to the marketers to give to their customers. The issue is, most of the time the companies exempt themselves from liability. In between the lines of that form or that agreement that they give to you, the marketer, to give to your customers, if you hire a good lawyer, which is why I always advocate for you to get a good lawyer. I think some of the terminologies used might be things that are alien to the regular person, but a good lawyer would interpret those terminologies and tell you, oh, this particular one is saying that if there is a problem, if there is a liability, if the company goes bankrupt, if the company is unable to carry out the particular service or remit the goods or keep to the promise in general which they have asked you to make on their behalf to the customer, the company would not be liable. And so if the company is not liable, who then does the liability fall on? The liability falls on you, the marketer, which is why you need to protect yourself. In recent times, I've seen some contracts or some agreements given to the marketers by the companies. The companies go as far as removing their names. You would not see any mention of the company's name in the entire contract or in the entire document. You would only see a contract between Mr. A, who is the marketer, and Mr. B, who is the customer, where Mr. A is pledging to give Mr. B so and so, without mentioning that, oh, this person is actually our marketer and we are the ones that sent him forth. If they actually mention that, then when there's a problem, which sometimes arises because business is very unpredictable, so sometimes you're unable to keep to your promises naturally. But when there is a problem, Mr. B, who is the customer, would not be able to go after the company, because in the contract that was signed, it was signed strictly between Mr. A, the marketer, and Mr. B. So you find the customer going after the marketer, whereas it's not the marketer's fault. All the marketer did was collect your money and give to the company. It is the company that folded. It is the company that is unable to keep to their end of the bargain, not the marketer. But it's nobody's business. Nobody's going to want to listen to that story. So that's why, as a marketer, you need to go the extra mile of doing what? One simple thing: prepare your own agreement, prepare your own contract. I know that the companies usually have like I said before, a pre-printed contract or a pre-printed agreement that they expect you to give to your customers, but you cannot rely entirely on that. Protect your interest by preparing your own contract. Even if you can't hire a lawyer to do it for you, simply write it down on a piece of paper. I, Mr. blah 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 blah, promise to hand over the money or whatever it is you've collected from the customer to this company known as blah 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 blah. I am a marketer for the company, but I'm not liable to pay to the customer or to remit anything to the customer. It is only if the company pays me that I pay you. If the company folds, then you go after the company. So your liability in this transaction, in fact, you should spell it out and say the liability in this transaction is going to be borne entirely by the company. You mention the name of the company there. You explain it to your customer. So it's not a case of, oh, you didn't tell me, you explain to your customer, this is company that I'm working for. They are the ones that would pay you, or they are the ones that will give you the service. And then you get the customer to sign that, oh, you have explained to him that it is the company that will pay him. That way people would not come after you. So why not protect yourself by getting an agreement on the side? If you cannot hire a lawyer to do, you can do it yourself. Simply write on a piece of paper that you're not going to be liable. Instead, liability will be on the company. Simply write on a piece of paper that you're not the one paying, it is the company paying. Simply write on a piece of paper that you're a marketer or you're an agent for the company. And so just like the principal and agent theory that we all know in commercial law, you cannot be liable except for acts that you do without the consent of your principal, which in this case you're not doing without the consent of your principal because they actually authorized you to do those acts. So why not put those things down on a piece of paper, get to your customer to sign, and be free from unnecessary liability? So I hope with this video you've been able to understand the basic tips to get yourself free from liability as a marketer in Nigeria. Thank you.